everyone hear me? No. It was working before.
I think it's working. It's just not like it's going.
Okay. My name is Chris Sokol. I'm on the Speakers Committee of the League of Women Voters of Moscow. Today we're hearing from Geoff Heeren, who's Professor of Law and Director of the Immigration, Litigation, and Appellate Clinic at the University of Idaho, on the topic of the embattled state of immigrant rights. In addition to his clinic director duties, Geoff teaches a course on immigration law and policy. He has published several articles and essays concerning immigration law, including in the Wisconsin Law Review, Cardozo Law Review, Harvard Civil Rights and Civil Liberties Law Review, among others. Before joining the University of Idaho, he was a professor at Valparaiso University Law School, where he founded and directed the Immigration Law Clinic. Previously, he was a clinical teaching fellow in the Asylum Clinic at Georgetown Law. He first practiced immigration law at Legal Aid Chicago, where he handled direct representation of immigrants in detention, federal appellate work, and affirmative civil rights litigation. While working as a legal aid attorney in Chicago, he also taught asylum law as a lecturer at the University of Chicago. He received his JD from New York University School of Law and his undergraduate degree from the University of Chicago. Welcome, Geoff.
Hi, everybody. Thank you very much for having me here. It's wonderful to be here in this lovely room with all of you. Thank you for caring about this issue. I speak every week with immigrant clients, so Chris mentioned I direct the immigration clinic at the University of Idaho, so I'm speaking on the phone regularly with immigrants, and I can tell you that this is a time of fear and uncertainty for many immigrants in the United States, and also heartbreak, and I think it's really important to acknowledge that before I go into some of the complicated legal questions and policy questions that I'm going to talk about today. So my thought was that I would start out by telling you all a little bit about what I do and about what my clinic does, and then give you some basic information about the immigration system in the United States and how it has worked historically, and then in the process of doing that, talk a little bit about a lot of the recent changes, because there have been many changes recently in just a short period of time, and I'm going to talk about the impact of those changes so far. So I do direct the immigration clinic at the University of Idaho College of Law. I've been practicing immigration law for longer than I care to admit, and I started out, as Chris said, representing detained immigrants in Chicago, and then went on and worked at the other places that were mentioned. I'm very happy to be here now in Idaho. I've always loved the West, and I'm happy to be in the West. We don't have a lot of immigrant rights resources and immigrant legal aid in Idaho, so I think it's important, especially important, that we have our clinic here, and it fills a really important role. We have offices here in Moscow and also in Boise. I'm in Moscow, and my wonderful colleague Betsaida Chavez-Gomez, who you see pictured here, is in Boise and co-directs the clinic with me. We usually have about 8 students who are distributed evenly in both locations. The students represent clients in really high-stakes cases, so they're representing clients who are in removal proceedings, who are facing potential deportation. They're representing asylum seekers. They're handling appeals. Just last week, I had 2 students who argued in the Ninth Circuit Court of Appeals, which is one step below the U.S. Supreme Court, so a very high level of litigation. And they did a phenomenal job arguing in front of a panel of 3 judges on behalf of an asylum seeker. Another thing that we do that I'm really proud of is that we provide consultations, free consultations to non-citizens who are students at the University of Idaho or at Washington State University. And as you can imagine, we've had a lot of questions, unique questions in the past weeks from our clients who are students at the University of Idaho and Washington State University. So I want to start out now by giving you some kind of basic information about how the immigration system works. How many of you know something about immigration law? All right, wonderful. So I can say anything. It is an extremely complex area of law. It's been compared to tax law as one of the most, if not the most, complicated areas of U.S. law. There are no less than 5 government agencies that have some cabinet-level agencies that have some involvement in immigration law, starting with the Department of Homeland Security, which was created after 9/11, and the Department of Homeland Security the Department of Homeland Security adjudicates applications for immigration benefits, and it also enforces immigration law. So it patrols the borders, apprehends individuals in the interior. It does all of those things. The Department of Justice oversees the immigration courts with immigration judges. The Department of State adjudicates visa applications from outside the United States to come into the United States. The Department of Labor handles certain aspects of employer-based petitions for immigration. And last, the Department of Health and Human Services handles the resettlement of unaccompanied immigrant children in the United States. Now, this is even more complicated because there are actually 3 sub-agencies of the Department of Homeland Security that are involved in immigration. We have U.S. Citizenship and Immigration Services, which processes immigration applications. We have Immigration and Customs Enforcement, which enforces immigration law, apprehends individuals, detains persons, and deports them from the United States. And then we have Customs and Border Protection, which you've likely encountered if you've ever flown into the United States after an international trip, and they're also at the borders as well. I'm going to talk a little bit about immigration status because I think that there's a widely held misconception that status is really simple, that we have undocumented immigrants and then we have citizens, and that's it. But in fact, there is a really complex set of immigration statuses. And one of my colleagues, Professor Virgil Levy, who teaches in Minnesota, has used a metaphor of a hotel to describe immigration status. So just as a hotel might have different floors with different purposes, the immigration hotel starts out with the condominium floor at the top, and we have U.S. citizens there who have the most rights in the United States. They can vote, they can do everything that citizens can do, and that's why the condominium is the metaphor for citizenship. Below that, we have the apartment floor, and here we have those who have green cards, also known as lawful permanent residents. They can come into and out of the United States at will. They can stay as long as they want, and they can work lawfully in the United States. Below that, we have a sanctuary floor, or a floor of refuge for refugees and asylees, those who have fled persecution in other countries to come to the United States. And then below that, we have a hotel floor for what are called non-immigrants. And these are called non-immigrants because they are temporary visa holders coming into the United States, typically for a temporary period of time and for a specific purpose. Below that, we have a very confusing set of statuses. This is the lobby, and the notion here is that people might be coming in and out. We have something called parole, which I'll discuss more in a little bit. We have something called deferred action, and I'll discuss that more in a little bit as well. And below that, we have unauthorized status. So these are the undocumented immigrants who are subject essentially to deportation at will. And then below that, even the dungeon, which is a metaphor for immigration detention. And like an actual dungeon, I can assure you, since I've been in immigration detention many times, not myself, but as a visitor, that it is extremely unpleasant, much like a dungeon. So those are kind of the main immigration statuses. And I want to talk a little bit about each, well, at least about some of these. And I want to start out by talking about citizenship, because citizenship has been in the news a lot lately. Historically, even before the Civil War, under common law, all persons, at least all free white persons born in the United States, were considered citizens of the United States. Now, I'm sure many of you have heard of the infamous case of Dred Scott versus Sanford. In that case, which is, I think, one of the developments that led to the Civil War, the Supreme Court held that a black man could not be a citizen of the United States, that even free black persons could not be citizens. Then we had the Civil War, and afterward, the Congress enacted the 14th Amendment to the United States Constitution to clarify that all persons born in the United States, including formerly enslaved black persons, were now citizens of the United States, and the text of the 14th Amendment is here. Now in 1890, 1998, the United States considered the case of United States versus Wong Kim Ark, and it involved a person who had been born in the United States, Wong Kim Ark. He had been born to Chinese immigrant parents, and at that time, Chinese individuals were subject to pervasive discrimination and mistreatment in the United States. They were essentially the closest thing at the time to undocumented immigrants. The categories, legal categories, were somewhat different at that time, but Chinese individuals were excludable from the United States, meaning they could not enter. They were deportable if they did not comply with very strict registration requirements, and they were subject to harsh punishments. And so essentially they were a class of persons who were subject to systemic discrimination, and yet the United States Supreme Court held that Wong Kim Ark was a citizen of the United States because he was born in the United States and that his parents were subject to the jurisdiction of the United States in the sense that they could be prosecuted. They were subject to those registration requirements and so forth. And that's the way that this provision has been interpreted ever since, that anyone who is born in the United States, even if their parents are undocumented, are citizens of the United States. Now, President Trump, shortly after taking office, signed an executive order attempting to end birthright citizenship for children born after February 19th, 2025 to unauthorized immigrants or temporary visa holders in the United States. And the administration's interpretation of the clause subject to the jurisdiction is that undocumented immigrants are not subject to the jurisdiction of the United States. Again, this is different than the way this clause has historically been interpreted, going back to the case of Wong Kim Ark. And in fact, the order has been challenged by about half the states in the United States, various immigrant right groups, and pregnant women who have an interest in making sure that their children are US citizens. And in every single one of those cases, injunctions have been issued, and those the government's request for a stay of those injunctions is pending at the US Supreme Court right now, which will likely weigh in on this issue at some point. So let's talk about non-immigrant visas next. Again, these are visas for persons coming temporarily to the United States. They could be students, they could be business people, they could be athletes. There are many, many different types of non-immigrant visas. What they typically have in common, again, is that it's for a temporary time. The person is not intending to remain permanently in the United States. Now, the Trump administration has cast doubt on the security of non-immigrant visas. This month, the US revoked visas for all nationals from South Sudan. And as I'll discuss later, the administration has also been revoking lately the visas of students, many students in the United States. And I'll be talking more about that in a little bit. Let's talk about green cards. So there are four main ways to get a green card in the United States. One way is through a family member's petition, a family member who has status in the United States, like a green card or citizenship. Another is through an employer's petition, if there are not a sufficient number of employees in the United States to do a particular type of job. Another is through an annual lottery called the Diversity Visa Lottery that is set up to make sure that there's a pathway to the United States for persons from countries that are underrepresented in the US population. And last is through various forms of humanitarian relief. Bless you, that I'm going to discuss in a minute. The Trump administration, I should say, has also stated its intention to create something called a gold card residency program that would offer a path to residency for persons who are essentially able to buy residency with $5 million. And at the same time, the Trump administration has paused adjudicating refugee and green card applications filed by asylees and refugees to pursue additional vetting and security vetting. I should say that many of these asylees and refugees are persons who were given asylum or refugee status during the first Trump administration, so already have been subject to all the vetting that would have occurred at that point in time. And there's additional vetting that occurs as part of the ordinary process of seeking a green card as a refugee or an asylee. The pause, of course, will likely delay these individuals from obtaining green cards and eventually naturalize and delay them from voting, which is, I know, something that is a particular concern to this group. Let me tell you about some of these humanitarian statuses. So I just mentioned refugees and asylees. By way of background, asylees and refugees have to meet a complicated legal standard where they show that they have a well-founded fear of persecution in another country based on certain protected grounds like race, religion, membership in a particular social group, or political opinion. The Trump administration has suspended refugee admissions for 90 days, again, to pursue additional vetting. It also has reinstated a program from the first Trump administration called the Migrant Protection Protocol, colloquially known as Remain in Mexico. This is a program that basically requires asylum seekers to wait outside of Mexico while their asylum cases are coming up for hearing in front of a US court. What happened during the first Trump administration is that it led to the creation of de facto refugee camps, often incredibly dangerous places on the US border with Mexico, across the border. And many of the people living in those camps waiting for their hearings missed their hearings because, as you can imagine, it's very difficult to get notice of a hearing when you're living in unsecure conditions in a refugee camp. And so very commonly, the MPP, or Remain in Mexico, resulted in denials of asylum cases almost uniformly, and removal orders for persons who typically would miss their hearings. Now, the reinstatement of that program has been challenged in court in an existing class action lawsuit that had been challenging some of the harms that resulted from the first incarnation of the policy. One other humanitarian benefit is humanitarian parole. And parole is basically a very flexible mechanism that the US has used throughout its history to allow in individuals who oftentimes have, oftentimes their lives are at risk in other countries, but they don't fit squarely within some of our existing legal categories like asylum. So for example, during the Cold War era, the United States paroled in tens of thousands of Hungarians. During the period following the Soviet occupation of Hungary. More recently, we paroled in many Afghan allies after the fall of Afghanistan to the Taliban. The Biden administration also had a parole program that it created for nationals from Cuba, Haiti, Nicaragua, and Venezuela. And the idea was to create sort of a more orderly mechanism for individuals from those countries to seek entry into the United States, as opposed to all coming to the border. The Trump administration has ended that program. It has also, there are reports indicating it's considering ending parole for Ukrainians who were granted parole. That could impact as many as 240,000 Ukrainian individuals in the United States. And so parole is in question during the current administration. Another humanitarian benefit that's listed on the slide is temporary protected status. Temporary protected status is a benefit that exists for individuals from countries that are in a state of warfare or occasionally natural disasters, and allows the president to designate that country for TPS, and then individuals who are from that country in the US can seek TPS if they were here as of a particular registration date. And on February 5th, DHS Secretary Christine Young terminated TPS for Venezuela, impacting approximately 350,000 individuals. That termination has been at least temporarily halted by court order. And the administration has also announced an end to TPS for Haiti as of August of 2025. Who here has heard of DACA? Okay, so everyone. So you may not know all the particulars of immigration law, but almost everyone has heard of DACA. DACA, of course, came into being in 2013 after many failed efforts in Congress to pass something called the DREAM Act. The DREAM Act essentially would have created a pathway to residency for individuals who were brought here at a young age, so oftentimes coming here as kids and had grown up, gone to school in the United States. And there's a lot of bipartisan support for the DREAM Act. It's come very, very close to passing many times, but has never quite passed. So President Obama said that because there's a likelihood that at some point this bill might pass, I am not going to use the resources of the federal government to deport this group of individuals. So essentially, it's an act of prosecutorial discretion on the part of the government to deprioritize the deportation of people who would meet certain requirements that were the requirements usually put forward for the DREAM Act. And it was controversial. It's had a very complex history with in light of litigation. The first Trump administration attempted to end DACA, and then the Supreme Court found that the Trump administration had not gone through the proper steps to eliminate it, so it remained in existence. But a number of states, including Texas, sued to get rid of DACA. And after Biden came into office, that litigation heated up, and a district court in Texas in 2021 held that DACA was illegal and that USCIS should not accept any new applications. They found that the entire program was illegal, but they allowed USCIS to continue renewing applications while the litigation ran its course. And so there was a pause on new applications, but an allowance for USCIS to continue renewing existing cases. What has happened now is that the Fifth Circuit Court of Appeals, which is based in Texas, has upheld the district court's injunction. And that decision came down in January. It's now final. What's called a mandate has now issued in that case. I think that the parties still technically have until April to seek Supreme Court review, but I don't think either parties, the US government or the state of Texas, are going to do that. So the decision is essentially final. And the decision is interesting because it does change the district court's analysis somewhat. First of all, the Fifth Circuit said that the injunction should be limited to Texas. So it actually doesn't apply outside of Texas. Secondly, it found that what was really unlawful about the program was the issuance of employment authorization. And it found that just deciding not to deport someone is not illegal. And so as a result, the injunction only prevents the government from granting employment authorization to DACA recipients in the state of Texas. That means that in theory, the US government could start granting DACA again outside of Texas. I've seen no indication that the Trump administration is going to do that. That opens the door probably for somebody to sue the Trump administration for not complying with its own regulations, the government's own regulations for DACA. So far, this issue has kind of flown under the radar, probably because there's so much else going on in immigration law. And a big part of what else is going on in immigration law right now is the president's declaration that there is an invasion at the southern border of the United States, an invasion of undocumented immigrants, and all the actions he's taken based on that claim. On the first day back in office, President Trump declared a national emergency at the southern border, and he deployed armed forces to the border to resume construction of the border wall and to participate in border security efforts. He also designated drug cartels as foreign terrorist organizations. And so this raises the question, is there in fact an invasion of the United States by undocumented immigrants? Now, I was not able to find recent statistics. These statistics lately have been somewhat hard to come by, but the number of undocumented immigrants in the United States has historically been fairly static since about the middle of the last decade, at about 11 million persons. It's gone up and gone down a little bit, but for the most part, it's been fairly static. And my guess is that it's probably about 11 million people right now, and that the number has not really gone up or down too much in the last years. Now, these 11 million individuals are heavily incorporated into the United States economy. They work at a disproportionately high rate relative to the rest of the US population, and they're doing many jobs that are extremely important, especially agricultural work and construction. And in Idaho, in particular, undocumented immigrants are heavily involved in our state's dairy industry, which, if you listen to the Dairymen's Association, the work would be very difficult to do without reliance on that labor source and without the support of those people who are doing those jobs right now. And that's an industry that's extremely vital to our state's economy. Now, I think that there's this conception that everyone who's undocumented in this country illegally crossed the border, but in fact, there are two ways to be undocumented in the United States. One is if somebody entered without inspection. The other is if somebody overstayed a visa. And again, recent statistics are very hard to come by, but at least as of 2014, the number of people who overstayed their visa was much higher than the number of people who entered without inspection, which also, I think, undermines the president's claim that there's an invasion at the southern border. And my sense is that although the numbers maybe look somewhat different today, there's still, I'm sure, a very high percentage of the undocumented population consists of people who entered lawfully into the United States, but then overstayed their visa for a variety of reasons that people do. So one of the main topics of the topic of my presentation is the embattled state of immigrant rights in the United States. And I want to talk about the rights in particular that undocumented immigrants have in the United States. Now, many of the core constitutional provisions that are the most important to people in the United States, the provisions in the Bill of Rights, things like equal protection, due process, those provisions are not written to apply to citizens. They apply to all persons in the United States. Things like the First Amendment, freedom of speech and freedom of religion, and the Fourth Amendment, freedom to be free from unreasonable searches and seizures, apply to the people, again, not to citizens. So these are provisions which apply to everyone in the United States, and undocumented immigrants have historically been held to have these rights. At the same time, there is a history of the US government targeting non-citizens using extremely aggressive methods based on their beliefs and their political views or their statements. And so, for example, during the 1919 through 1920 Palmer raids, Attorney General Mitchell Palmer and J. Edgar Hoover conducted a series of raids, arrests, and deportations of non-citizens who were alleged to be anarchists, communists, or other political radicals. Principally, these raids targeted Eastern and Southern European immigrants in the United States, many of whom were labor organizers or members of socialist groups. And there were warrantless searches, mass arrests, physical abuse, and extended detention without charges, as found by Justice Felix Frankfurter, who was one of the authors of a report afterwards of the activities during this period of time. Over 10,000 people were arrested in late 19 and early 1920, and among the many persons who were deported was the prominent radical Emma Goldman and her husband. Yet, these actions produced a backlash. The ACLU was largely formed in response to the Palmer raids. The Supreme Court held in 1925 that the First Amendment applied to the states, and that was the beginning of our modern era of much more robust First Amendment protection and protection of free speech in our country. So there was, I think, a backlash which led to really a growth in the rights that all Americans have today as a result of this period of draconian government action. Now, we saw some of the same things happening again during the McCarthy era and the Cold War, and again, then the government targeted non-citizens. Congress passed the Alien Registration Act of 1940, or the Smith Act, which criminalized advocating the overthrow of the government and made it possible to prosecute individuals and deport non-citizens based on their membership in the Communist Party of the United States. And that act was used as the basis for a 20-year deportation effort against Harry Bridges, who you see on this slide, who was a prominent Australian labor organizer. His case went to the US Supreme Court 2 times, and the second time it went to the court in 1945. The court stated that non-citizens have a right to free speech in our country. And that has been the law since then. Nonetheless, the Trump administration has begun targeting non-citizens for exercising their free speech rights. And this administration has revoked a large number of F student visas, and the number keeps going up every single day. So I think I wrote 300 based on this slide, but that was as of a number of days ago, and I'm sure the number is higher today. And the revocations are based on the political activity of these individuals, typically oftentimes in pro-Palestinian protests that occurred at university campuses around the United States. And the administration has also put numerous academics into deportation proceedings based on an immigration law provision that allows the Secretary of State the power to deport non-citizens that the Secretary, if the Secretary determines that their continued presence would, quote, threaten foreign policy. As laid out in an amicus brief filed by law professors in 2 of these cases, this interpretation has never been used this broadly before to apply to people based on their political actions throughout the United States as part of a protest movement. And as it's being applied, it could be applied with almost no restraints whatsoever. So for example, could the Secretary of State determine that individuals who engage in climate protests are violating the US policy of energy dependence? We don't know, because the provision as it's being applied right now, it has almost no limitation at all. And that's why the courts may find that it violates due process. So what rights do non-citizens have in immigration enforcement actions? There are three principal rights that I would identify that historically non-citizens have had when they are subject to immigration enforcement. One is the right to remain silent, which comes from the Fifth Amendment privilege against self-incrimination. Another is the right to be free from unreasonable searches and seizures, which comes from the Fourth Amendment. And the last is the right to be represented by an attorney. And in the criminal context, that comes from the Sixth Amendment, but in the immigration context, it's part of the due process protections provided by the Fifth Amendment. Now, I want to distinguish between the right to representation in the immigration and the criminal context, because in the criminal context, there's a right to appointed counsel for persons who can't afford a lawyer, but that's not the case in immigration court. In immigration court, the right to representation means that the government cannot stand in the way of somebody from obtaining an attorney, but is not a right to an attorney paid for by the government. There were some moves prior to the Trump administration to increase access to counsel for non-citizens in removal proceedings, at least for the most vulnerable non-citizens in removal proceedings. So for example, the Trafficking Victims Protection Reauthorization Act of 2008 required the government to assure to the greatest extent practicable that all unaccompanied immigrant children in removal proceedings have access to an attorney. And the government had contracts with a nonprofit to funnel money to other nonprofits throughout the United States to try to increase access to counsel for kids who are in removal proceedings. The Trump administration has canceled now those contracts for providing representation to about 26,000 unaccompanied immigrant kids in removal proceedings, resulting in layoffs at these nonprofits around the country where legal aid lawyers were working to represent kids in removal proceedings. So Raíces, which is a major legal aid organization, announced over 150 staff cuts, and Kind, which is another large organization dedicated to representing kids, had to close most of its offices. A federal judge has ordered a temporary restoration of these services, but the long-term future of these programs as a result, as well as other programs that guarantee sort of legal orientation and information, all of those programs are uncertain in the Trump administration. I want to explain now a little bit about how deportation has historically worked, and then talk about some recent changes to the deportation process. Typically in deportation cases, the first step is that after somebody is apprehended by an ICE officer, the officer makes a determination whether the person should be served with a notice to appear for immigration court, or whether they can be put in an expedited process called expedited removal. And persons who are in expedited removal don't ever get to go in front of a judge. They're deported based on paperwork issued by an officer. This is something that's existed in US law since 1996. The one sort of escape valve from expedited removal is if somebody expresses a credible fear of persecution in their country of origin, then they, if the officer finds that they have a credible fear, their case goes back to the immigration court side of this infographic, and they go to a removal hearing in front of an immigration judge. In front of an immigration judge, somebody could contest the charges against them and argue that the case should be terminated. For example, if they were arrested in violation of their Fourth Amendment rights, they could assert that as a defense to deportation, or they could request some type of affirmative relief, like asylum. The judge could terminate proceedings, the judge could grant asylum, and in those cases, the removal proceeding ends. And if the person was granted relief, they can go and obtain that status and potentially a green card and eventually citizenship. Alternatively, if they lose their case, they have a right to appeal to an administrative appeals board called the Board of Immigration Appeals, and then to the Circuit Court of Appeals. I mentioned that my students had argued in the Ninth Circuit Court of Appeals, so that would be an example of the Circuit Court. In theory, they could go to the US Supreme Court too, but the US Supreme Court takes very few cases and very few immigration court cases. So that's kind of the typical process. If somebody's in detention, I should say also that they can seek bond. So these are kind of the rights that somebody has within the removal process. I want to say that at the Board of Immigration Appeals, the Trump administration has now fired all of the board members who were appointed during the Biden administration, reducing the number of board judges from 28 to 15 members, despite the fact that there's an enormous backlog of cases at the board. So one would think that it would be an all hands on deck situation where you would need as many board members as possible. Now, there have been a number of changes, as I mentioned. One is that initially the administration began using Guantanamo to house immigrant detainees. But the reality was that the detention center didn't offer the administration very many real advantages because persons who were there unquestionably were still entitled to all the rights that somebody would have within a removal proceeding. So there was very little advantage to the administration in terms of expediting cases, and there were a lot of logistical challenges. So that, as far as I can tell, that program has been ended, and there are currently no immigration detainees at Guantanamo, leaving aside again the residual population of war on terror persons who are at Guantanamo, which is a separate population. A more serious change is that the Trump administration has expedited, or has rather increased its use of expedited removal. So until recently, expedited removal was applied within 100 miles of the US border to persons who could not prove to an officer that they'd been in the United States for 2 years or more. The administration has now expanded it to the entire United States, to anyone who cannot prove that they've been in the US for 2 years or more. Part of the reason why historically there was a more limited scope for expedited removal was that there are some serious due process questions about requiring somebody to affirmatively prove that they've been here for some period of time, and to do that to an officer who's not a judge, is not a neutral arbiter of a case, and without any possibility of an appeal, and without even any timeline or real process for submitting that information or any real checks on it. So there's some real due process questions, and the ACLU has sued in January to try to stop the expansion of expedited removal. But as far as I know, I believe it is in effect at the moment throughout the United States. Another change is that the administration has repealed the sensitive locations memo that had previously prevented the government from enforcing immigration law at churches, hospitals, and schools. So now the administration has stated that it will henceforth be enforcing immigration law in all of those places. And a number of religious denominations, various Quaker groups, Unitarian churches, Jewish congregations, a large number of different religious denominations have filed lawsuits arguing that this violates their First Amendment freedom of religion to go into churches during worship services while people are praying and deport them from the United States. Another change is that DHS has dusted off the modern version of the 1940 alien registration law that I mentioned that had been the basis for the prosecution of Harry Bridges, I'm sorry. And it is now required, in modern times, the alien registration provision has not been widely enforced, but the Trump administration has stated that all undocumented persons in the United States have to come forward and register, and if they fail to do so, they can not only be deported, but also prosecuted for failing to register. Probably one of the biggest changes is that in March of 2025, President Trump invoked the Alien Enemies Act of 1798 for the first time since World War II, claiming that the Venezuelan gang Tren de Aragua constituted an invasion of the United States. The Alien Act was part of the Alien and Sedition Acts, which were heavily criticized at the time by no less than Thomas Jefferson and I believe James Madison, and since then have been widely criticized by historians and legal figures, just as Hugo Black stated that they had been, quote, repudiated by history, and yet the Trump administration has invoked it to justify the deportation of members of the Tren de Aragua gang, or alleged members, I should say, because the Trump administration has not created any process for their membership in that gang to be adjudicated. And in fact, over 130 Venezuelan nationals were deported to El Salvador, where they are detained in the Terrorism Confinement Center, which is a very scary prison in El Salvador. And these deportations occurred despite a federal judge's order temporarily enjoining deportations while he considered the legality of the use of the Alien Enemies Act. During a hearing on April 3rd of 2025, Judge Boasberg, the judge in that case, indicated that the administration may have acted in bad faith by deporting persons while his TRO was in effect. The Justice Department has defended its actions, arguing that the court's order did not apply to flights already in transit, and asserting that the judge overstepped his authority. The Supreme Court, just this week, has now vacated Judge Boasberg's TROs, holding that the challengers should have brought, it's a very procedural decision. It's not a decision that nobody has a right to challenge the invocation of the Alien Enemies Act. Instead, the decision is that those challenges need to be brought as habeas petitions in the district in Texas where they were initially detained, or wherever they're initially detained. So that's the reason why the Supreme Court has vacated Judge Boasberg's TROs. If you're wondering who some of the gang members who have been deported to El Salvador, to this prison in El Salvador are, one example is Kilmar Armando Abrego Garcia. He was not deported, I don't believe, pursuant to the Alien Enemies Act, but he was deported to this prison in El Salvador, which you see depicted here in a video that, as I understand it, the government of El Salvador itself released, and his wife, who you see depicted here, identified him in that video. He has a wife and a U.S. citizen son. And the thing that's most remarkable about his deportation is that he was granted a benefit called withholding of removal in 2019, where a judge held that he could not be deported to El Salvador, the exact place that the Trump administration deported him to. And DOJ Department of Justice Attorney Erez Ravini admitted in court proceedings that his deportation was an administrative error. Soon afterward, the Trump administration put him, as well as his supervisor, on indefinite paid leave. That judge, the judge in that case, District Court Judge Paula Zinnes, has ordered Abrego's return, but the Trump administration has appealed. The Fourth Circuit denied the Trump administration's request for a stay of Judge Zinnes's order that he be returned. And the full stay decision is at the Supreme Court right now. The Supreme Court has issued an administrative stay, which means that they're not requiring that he be brought back right now, but they're taking briefing and they'll be deciding this case as in the time going forward. Now, the Trump administration's position is that it does not have the authority to order the president of El Salvador to do anything. Abrego's position is that the court has the power to order the government to at least try to return him. And in fact, there are probably many diplomatic measures that the US government could take to try to get somebody back from El Salvador and to work with the Salvadoran government. As law professor Stephen Vladeck put it, a world in which federal courts lack the power to order the government to take every possible step to bring back to the United States individuals like Abrego Garcia is a world in which the government could send any of us to a Salvadoran prison without due process. Claim that the misstep was the result of administrative error and thereby wash its hands of any responsibility for what happens next. And that's, I think, a world that none of us want to live in. Let's talk about sanctuary cities now. States and cities are really all over the map, no pun intended, when it comes to immigration enforcement. There is really, that being said, there really is no such thing as a true sanctuary city or state. ICE can enforce immigration law anywhere in the United States, and federal law prohibits state and local governments from restricting agencies from sharing information with ICE. That being said, federal law does not impose any affirmative obligation on state or local governments to gather immigration information, and some states and local governments, like Washington, for example, have made the decision that they're simply not going to gather information about immigration status from people, and so that's Washington law. Washington law also prohibits local law enforcement agencies from complying with ICE detainers, which are essentially requests from ICE to a local law enforcement office to hold somebody in detention until ICE can come pick them up. And their courts have held that their requests, they're not mandatory, and so Washington law says that state and local governments are required to comply with those. San Francisco, along with other cities and counties, also has some of these same types of policies in place. And they've gone to the extent that they've gone to court with the Trump administration. They've sued the Trump administration to challenge its effort to coerce local governments into assisting with federal immigration enforcement. Conversely, the Department of Justice has also gone to court, and it's sued the city of Chicago, the state of Illinois, and New York State, arguing that their policies obstruct federal enforcement of immigration law. One of the key issues in these cases is the 10th Amendment to the United States Constitution, which reserves certain powers to states. And there's a principle under the 10th Amendment that the federal government cannot commandeer states and localities to assisting with federal efforts by withholding funds or otherwise using those types of tactics to try to force compliance. Now, for every state that resists enforcement, there's one that's eager to cooperate. One example is Idaho. And Idaho law prohibits local governments from restricting information sharing with ICE or refusing to cooperate with ICE. And Idaho has recently enacted, just in the past weeks, a law, HB 83, that would enlist state police in immigration enforcement in cases in which they arrest or detain or even investigate a non-citizen for other reasons. The ACLU went to court within hours of the governor's signature on that law, and that law is currently subject to a temporary restraining order, and that case is being briefed in district court in Idaho right now. So that's more or less the lay of the land right now, and we have states and local governments really taking wildly different stances on immigration enforcement across the country. We have a federal administration, the Trump administration, that has engaged in a really broad, systematic effort to upend immigration policy. The administration has not only targeted undocumented immigrants, it's also targeted legal residents, students, asylum seekers, and even immigration lawyers. And in my view, the administration's efforts challenge our basic constitutional norms like freedom of speech, due process, and even the rule of law itself. Thank you. And I'd be happy to take any questions if you all have any. Yes?
So during the last Trump administration, I was going to see a friend of mine on the west side, and I took the bus. It was winter time. And when the bus was in Spokane, ICE came on the bus and was asking everybody for identification. I had my passport with me. I was really angry, very uncomfortable. And I almost thought about telling the ICE officer in Spanish that I didn't speak English. So what could a person do in that situation to take a stand against that kind of invasion? I felt kind of under attack myself, even though, I'm not an immigrant, and I have my documentation and everything. It just seemed so horribly wrong to me. And I know that there was a lot of talk about that in the newspapers after the fact, and I can't remember exactly what the state of Washington was doing about it, but something is happening as a result.
Yeah, so I guess going back to the rights that somebody has in immigration enforcement. So the people on the bus have the rights that I mentioned, the kind of three basic rights that I mentioned, and somebody who is undocumented, who's on a bus that's boarded by, it might have been in that case, a CBP officer actually, has the right to remain silent. CBP has the ability to arrest somebody if they think they have reasonable suspicion that the individual is a non-citizen. In certain border regions, they consider themselves to have kind of enhanced enforcement capabilities. So I'm not sure exactly where you were relative to the border at that point in time.
Spokane.
Yeah, so probably not. in terms of what you can do as a citizen in that situation, one thing you can do is just be observant and write notes about what you're observing, and if you're seeing things that strike you as abusive or excessive, you can take notes concerning that. You could try to ask for the person's identification, their badge number, their name, and report that information. There used to be a DHS Office of Civil Rights and Civil Liberties. I do think I heard that that office has been eliminated under the Trump administration, but people do still have rights to challenge unreasonable searches and seizures, either in some cases in immigration court or through a separate lawsuit. So having independent observers' reports can be very useful in some of those situations.
Can we film it?
Sure.
Could you stand up and say, I don't agree with this?
Yes.
Can you tell the others on the bus you have the right to remain silent?
I think so. Now, keep in mind, there is federal law related to obstruction, and so anything you do, as you kind of amp up what you're doing, it creates more of a possibility that you yourself might be targeted and potentially subject to obstruction charges. So I think that exercising your right to free speech, saying that you don't agree with something, taking a video, in my view, those are all things that don't cross the line to obstruction. Those are your basic rights as a citizen. But I think that's something to be aware of, that if you're in that situation and you want to take brave action, you need to be aware that there could be a line that could be crossed, and that your view of where that line is may be different than what the officer's view is of the line. Yes?
I'm thinking about the canceling the contract for defending minors for law representation of minors in the courts, and so my daughter is the legal guardian of a refugee minor in Oregon, and Oregon provides the fees for the attorneys in Oregon. I wonder, in Idaho, does Idaho provide the fees for representation, or is it dependent on the federal government for those fees? And if Idaho doesn't provide the fees, is there capability for a 501c3 to people to donate to provide those fees?
Yeah, so Oregon does actually, under Oregon state law, provide funding for representation of non-citizens in removal proceedings. It's one of a few states that does that. Idaho certainly does not provide any funds for representation of non-citizens in removal proceedings. There are GALs in state court proceedings that are totally unrelated, that are funded, I think, in some cases through state funding. But if we're talking immigration proceedings, no, absolutely not. Idaho doesn't provide any funds. There are some nonprofits. There are not very many in Idaho that do some of that work. There's an organization called the Alliance for Idaho, based in Haley, that does that. We used to have an organization called Immigrant Justice Idaho. It's since closed. There's an organization called Familias Unidas near Boise that does a little bit of representation, but I think they've had to step back, and I don't believe they're doing any representation anymore in removal proceedings. And then there's my clinic. So those are really the only organizations. And I think that my clinic and probably Alliance for Idaho are the two main organizations that really provide removal defense to kids in Idaho.
Child refugees are expected to defend themselves in Idaho in general, or is it just not child refugees?
Yeah, so I would say yes. There, again, the right to representation. There's the law that I mentioned, the Trafficking Victims Protection Reauthorization Act, which does impose an obligation of the U.S. government to try to assure representation. And a federal judge has found that the Trump administration's cancellation of that contract, I think, violates that provision. That litigation is ongoing, so we're going to have to see how that plays out. If the judge's order is upheld, and if there's a final preliminary injunction entered and that order is upheld on appeal, then we may see continued funding, federal funding. If not, there are going to be a lot of kids who are not going to have lawyers. And I can tell you, these proceedings are confusing and terrifying for adults. let alone for kids.
I love for 2-year-olds.
Yes, no, that's one of the saddest things that I've seen in my career. When I go to immigration court and I see kids there, it still breaks my heart.
Does the program court-appointed special, what is it, CASA, court-appointed advocates?
Yeah, special advocate.
Yeah, do they take any of these cases, or is it only abuse that they deal with?
Yeah, their CASA is very different kind of scope, and so that's related to state court proceedings, for example, termination of parental rights cases under state law, not removal cases under federal law. Yes.
So on campus, there has been talk that 2 international student visas have been revoked, even though the reason isn't confirmed or anything. A lot of like my own peers and colleagues that are international students themselves have been very shaken about it. Is there, I guess in a sense, is the first question asked like what we could do in that sense, even though we don't know who the specific ones that are getting their visas revoked, like how can, I guess as individuals, or what is there that we can do to like help support, or like, I guess in a sense like avoid like having that happen again, or speak up about it?
Yeah, so very little is known about, very little has been publicly disclosed about those 2 cases, but there was a spokesman article reporting on it, and I believe that article did suggest that at least one of the 2 cases was based on protected speech and was based on the provision that I mentioned earlier involving foreign policy, the foreign policy provision. Around the country, this has been happening at universities around the country, and individuals who have their visas revoked and have their CEVA status terminated because of their protected First Amendment activities have a right to file federal litigation to challenge that. In some cases, it's necessary to act very quickly because people can be put in detention. So to the extent that students are connected to that individual, that would be a good message to get out, that it's important to see a lawyer, to talk to a lawyer to see what your options might be. There are also cases where people have had their visas revoked based on criminal conduct, although oftentimes very minor criminal infractions that never would have been an issue in the past, sometimes even traffic issues. Those are probably tougher cases because they don't involve kind of the core First Amendment issues. I see those cases involving First Amendment claims to be very strong claims based on my understanding of constitutional law. So I think getting that message out to students, and to the extent that that student wants to take a stand, I think supporting that student, I think we all have, as has been pointed out today, free speech rights, and for everyone to stand up and say that this is not okay for people to be targeted based on their, even if you disagree with somebody's protest that they held. I think most Americans agree that that person has a right to protest, right? So I think potentially people have to just be speaking out about these issues. Yeah.
So what I'm hearing is if you have it, to probably contact or at least have the name of an attorney or a lawyer before you do that if you have immigrant status, is I think about the gal that it was the Tusk student. She was apprehended outside the university and then she was flown to Alabama. So how does she get an attorney? Perhaps, I mean, if you're gonna, this whole freedom of speech thing is horrific. Does everybody need to get an attorney or have somebody in mind before you open your mouth?
I don't think we're quite at that point yet, particularly not for citizens, but I do think that if you, as you said, as you pointed out, if you yourself are vulnerable because you don't have U.S. citizenship, it may be a good idea to have an immigration attorney number with you. It may be a good idea to research that and to have somebody that you know that you can contact.
Okay, we'll have to leave it there.
Okay, well, thank you so much to all of you for being here today.